everyone, and welcome to Thorough Newspaper Analysis, which is brought to you by LawSikho. So today we'll be discussing one article which is from the Hindu, and it has been titled as "A Concerted Attack on the RTI." So basically, it discusses the discrepancies that are now visible in the Right to Information Act due to the previous amendment that has taken place in the previous year, and as also the the vacancies that are there in the election commissions in India. And secondly, we have the news in flash, wherein we'll be discussing the small news articles that are more important for a prelims exam. Before that, let's have a look at the LawSikho courses that we have for you. So we have the Lord of the courses, that is a judiciary test prep course. So if you're also watching this news analysis and preparing for judicial services exam for any state for that matter, you can definitely have a look at this course. The link is there in the description box, and you can download free study material from there as well. With this, let's see that what is the multiple choice question for the day. Right to information was recognized as a fundamental right in which of the following cases? First, People's Union for Civil Liberties versus Union of India. Second, Lalita Kumari versus Government of UP. Third, DK Basu versus State of West Bengal. Or fourth, State of UP versus Raj Narayan. So if you know the right answer to this question, you may jot it down in the comment section below. Descriptive question. RTI is a tool for empowering ordinary citizens and changing the culture of governance in India. Discuss. So basically the role that the Right to Information Act has played in India and bringing transparency and accountability in the governance in India should be discussed in this answer. The word limit of this question is 250 to maximum 300 words. And here, for all those, we have been seeing that you have been asking for the PDF of this entire discussion. So we are very soon coming up with this initiative as well. And hopefully very soon you will be able to access the PDF as well. So yes, definitely we'll be doing something in this regard too. With this, let's start the discussion for the day. RTI, that is Right to Information. So the year 2020 marks 15 years of the enactment of the Right to Information Act 2005. Now, as we know that after year-long protest that actually happened coming from the ground level and from the grassroots level, RTI Act was finally enacted in the year 2005, and this year being 2020 has marked 15 years of the enactment of the RTI Act. The Supreme Court has held the information, that is right to information, as a fundamental right under Article 19 of the Constitution of India. Now, as we know that the RTI Act finds its place, or the right to information finds it emanating from the Article 19, which is freedom of speech and expression of the Constitution of India. Now, let's see that how the law is being used. So the current status, that how important this law has become for the entire country, let's analyze that. It is the most extensively used transparency legislation in the whole world. Now, keeping in mind the applications that come every year for the right to information, this law or this enactment has become the most extensively used transparency legislation, as in a legislation or a set of law that ensures transparency and accountability in the governance system. So for that matter, 6 million applications are filed every year. For 6 million, you should understand it means 60 lakh applications are filed every year. And most of these, like out of these 6 million applications, a large part of the applications come from the poorest and the most marginalized people, which actually makes this entire enactment a quite victorious one, because this is the moment when we realize that it is not only the people who are literate and who actually know about the schemes and the laws, but also the poor and marginalized sections of the society who are largely using this enactment to empower themselves and to get information and to hold the government that they are voting to be accountable. Secondly, even during the time of COVID-19, a lot of information was sought out through the RTI in the field of medical facilities, and also it held the government department accountable for delivery of food grains and social security benefits as well. And also queries were laid down regarding the PM CARES fund. Now, as we know, since from the time of beginning of the lockdown, when COVID-19 had hit India, the Pradhan Mantri CARES fund had been brought into the scene, wherein donations coming from various entities, people, businessmen, they actually had to be collected in this regard for the cure or for the help of COVID-19 patients and the victims of the or the family related to those people. And even that was demanded by the people to be brought under the ambit of RTI. And then by public spirited citizens, so shine light on corruption and arbitrary abuse of power. So there have been many whistleblowers and very, a lot of RTA activists as well, who have actually played a very significant role in bringing down the arbitrary abuse of power that actually in many times, in many situations, it takes place from the end of the government. And these whistleblowers and RTI activists have actually made sure that they question such movements that are done by the government, and they make them accountable from every now and then. Now here, this actually diverts to another area as well, wherein it is very important for us to make sure that we are ensuring the safety and security of these whistleblowers as well. So for that, we also have an act called as the Whistleblowers Protection Act of 2014. But then again, many times it has been seen that many RTA activists are also, they're put down, or even they're threatened by the people so that they don't, file RTIs, or so that, but that is something that really should not be stopping them, and we should make sure that we give good attention and security to these whistleblowers as well. Then moving back to the discussion, question the highest officials, obviously, because RTI is the one thing that, be it the highest a person in the hierarchy of government, if it is a government body, you can definitely question them. And trust me, even the RTI provides for that you can even question the functioning of your president and prime minister, because obviously it should not be defamatory, but obviously you can question as to what or in what ways they are using the funds. You can question your MP, MLA, or anyone for that matter. Then it is used for seeking information about the anonymous electoral bonds as well. Now, as we know that this entire issue of electoral bonds was also raised by a Supreme Court and also the Reserve Bank of India as well, wherein it said that, see, basically the idea of electoral bonds was like, if you being an individual, you could be any person, an industrialist, an individual, a working person, or anyone, and you wish to support any political party by giving some funds to that party as a donation. Now what you do is that, for example, you give 1000 rupees to that party. Now in exchange of that 1000 rupees, that party or the government actually, that party basically issues you electoral bonds. So bonds is basically a security, it's a kind of a exchange document kind of a thing, or it's a bill kind of a thing, that it gives you that so and so amount of money, such and such amount of money was given by such and such individual to this particular party. But the very issue with the electoral bonds was that this information could not be disclosed, and even till date it cannot be disclosed as to which individual gave how much amount of, or what amount of money to which political party. And this actually brought in the idea that this could actually put down the very idea that we are fighting for, of transparency and accountability. And here black money could be, it could survive very easily. And that is why a demand was, or it is still being made, that these electoral bonds should also be brought under the ambit of the RTI Act. And it created 1.3 billion potential whistleblowers and auditors. And just like I just mentioned, that there are a lot of whistleblowers and auditors as well, who actually take care of the expenditure, that if it is being spent in the right direction or not, it should not be misused or misappropriated in any situation. And this act has actually successfully created approximately 1.3 billion potential whistleblowers and auditors that keep a check on the government expenditure. But unfortunately, with all this victory and success stories that we have just read about, there have been also severe attacks on the RTI Act, as in on the functioning or the autonomy of the RTI Act. Now, first, let's understand the situation, that the reason why the election commissioners, or the chief election commissioner, or the state election commissioners, or the other commissioners that are associated with the SIC or CIC, the reason why they were able to function so independently and so in such an autonomous manner was that they were free, as in the government did not have a hold over their tenure or their salaries for that matter. Just like, take an example of police in India. Many a times, many police officers, they do not step out of the box to help the people, because they believe that if they would go against the authority or against the government or against the netas or MPs or MLAs for that matter, they would be transferred then and there, because their transfer, their term of service, as in their the conditions of their service, their salaries, these are all something that are defined by the government. And that is why if you have to take a step against the government only, obviously you will be crippled and you will not be able to take an unbiased decision. This was something from which the RTI Act was protected, and that is why any kind of information that was considered to be something that can be shared under the Act, it was shared by the officials without any fear of the government. But the 2019 amendment, unfortunately, that took place actually changed this entire system in the RTI Act, and it removed the statutory protection of fixed tenure and high status conferred on the commissioners, and it has now allowed the central government to determine the tenure and salaries of all the of all the information commissioners, due to which now obviously they're not able to function in an independent manner or in an autonomous manner. Now, these are the various changes that have been brought by the RTI Amendment Act in 2019. So you can go through them, but the major ones are these, that for the salaries and also for the appointment tenures and everything, it actually, the entire power has moved to the central government. And earlier it was already mentioned in the Act itself. So it was something statutory in nature, and it was not dependent on any other, on the mood of the government for that matter, but now it is. Now, the effect that it has had on RTI law is that, firstly, the governments have failed to appoint information commissioners. Now, as we know that if you must have read about the RTI Act, basically what happens is that it is the Chief Election Commissioner, or the Office of the Chief Election Commission, that is the highest body of appeal if you have any grievance regarding the functioning of the officials in the states for the Election Commission, or the the people, the public officers who are there appointed for this matter. Now, in such a situation, just imagine one situation wherein you know that the Supreme Court in India, for example, is the highest body of appeal, right? So you were not satisfied with the decision that came from the district court, not from the High Court as well, and now you think that you will be going to the Supreme Court. But now, once you approach the Supreme Court, you realize that there is nobody, no judge in the Supreme Court in totality to actually take your case and to give a decision upon that. Would you think that you have been served justice? Obviously not, because the highest body of appeal was vacant. Now, a similar unfortunate situation is occurring in the RTI as well, wherein the election commissions, and specifically the Chief Election Commission, is the highest body of appeal if we have any grievance regarding the functioning of the RTI in the states or districts for that matter. But these are more or less, they are prominently vacant from many years. So since May 2014, not a single commissioner of Chief Election Commissioner has been appointed without court's intervention. So that means that the court had to actually point out the situation, and only then they were appointed, unless before that they were all vacant. Despite the Supreme Court's order to fill all vacancies, even till date, 6 out of 11 posts of commissioners are currently vacant. Now you can just imagine that we already have a lot of pendency of cases. The burden is increasing every now and then. And in even such a scenario, we have 6 out of 11, that is in more than half of the posts of the election of the information commissioners are vacant, and even including the chief. So we do not even have a CIC in the current situation. So no chief information commissioner since 6 years. So this is really bizarre, because it has already been only 15 years that the RTI has completed, and out of those 15 years, 6 years we have already spent with an RTI system wherein we do not have even the chief election commissioner, chief information commissioner. Please pardon me, it just goes with the flow. So I meant chief information commissioner. And if we talk about the states particularly, then 8 state information commissioners are without a chief, and the commission in Tripura and Jharkhand are totally defunct, which is really a blot on the functioning, and this even on the setup of government, because it is really important that we ensure that all the vacancies are filled up and then they are functioning in the proper manner. So then an attack on RTI law is an attack on the foundations of a democratic republic, and a reflection of lack of political will to be answerable. Because obviously, if you are ready to be answerable, you think you are working in the best of the public benefit, you should be ready to answer the questions that come from the public. But if you are making situations so that people are not able to even question your functioning, it means that you do not want to be answerable to the public, which is very deterrent and which is very harmful for a democracy like India. With this, let's move towards the news and flash column. So we have one thing for the news and flash today: EVIN network to handle COVID-19 vaccine supply. So basically, EVIN stands for Electronic electronic vaccine intelligence network. Basically, it is a complete network that would make sure and that would actually check the movement of vaccines once we have the COVID vaccine in our hand. So this was actually empowered to track the latest vaccine position as to which vaccines are available, where are they available, the temperatures at which they have to be stored, the geotag health centers, and to maintain the facility level dashboard. It is now being given to the role to handle the delivery of COVID-19 vaccine. So we already, this is really a good step, because even before we have the vaccine in hand, we already are preparing ourselves for the better distribution and storage of these vaccines in India at least. So this decision was taken at the 21st meeting of the high level group of ministers, and this actually comes under the Ministry of Health and Family Welfare. So you should remember that what actually EVIN is, what it stands for, and what it actually deals with. So with this, we are done for the day. We hope it was a good session for you. Stay tuned with LawSikho for such more sessions to come. Thank you so much.